Corrigan. I'm the chair of the Enforcement Program Oversight Committee of the California Board of Accountancy. Welcome to the meeting, and I'd like to start by taking roll. If we could start at the end of the table with Ms. Hines, please.
Carrie Ann Farrell-Hines.
Michael Savoy.
Nancy Corrigan.
Mark Silverman.
Dan Jacobson.
Alicia Burhow.
Thank you. Looks like we have everybody present, definitely a quorum then. Moving on to Agenda Item 1, approval of the minutes of the January 17th, 2019 Enforcement Program Oversight Committee meeting.
I move to approve.
I second that.
Is there any further discussion among the committee members? Is there any discussion from the public? Being that there are none, may we call for the vote, please?
Alicia Burhow.
Yes.
Nancy Corrigan.
Yes.
Carrie Ann Farrell-Hines.
Yes.
Dan Jacobson.
Yes.
Michael Savoy.
Yes.
And Mark Silverman.
Yes.
So I'm going to direct us to Agenda Item Number 2. This is a discussion and possible action to initiate a rulemaking to amend Title 16, California Code of Regulations, Section 98, Disciplinary Guidance and Model Orders, Section 99, Substantial Relationship Criteria, and Section 99.1, Rehabilitation Criteria, and to adopt Title 16, California Code of Regulations, Section 99.2, Directly and Adversely Financial Crimes Criteria. Mr. Franzel, would you please begin your presentation?
Thank you and good morning. So the CBA for this item is being asked to approve the proposed language to amend the guidelines, CBA regulations sections 98, 99, and 99.1, adopt CBA regulations section 99.2, and direct staff to initiate the rulemaking process. At the January meeting, staff presented on attachments 1 through 4, which included proposed amendments to the guidelines, substantial relationship criteria, and rehabilitation criteria. Staff also noted that just prior to the January meeting, DCA had provided some options for model language related to these areas, but at that time, as we got at the Monday of that week of the board meeting, staff had yet to evaluate that language and provide any feedback to the board. Overall, the CBA supported the changes staff proposed, but requested that staff review the DCA language and assess if additional changes to the CBA proposed regulatory amendments were needed to be made. All of the proposed text before you today is presented in single underline and strike through format, and this includes any original modifications approved by the CBA in 2017, and those changes being presented to implement AB 2138. Staff did perform a review of the language DCA provided, which was for the substantial relationship criteria and rehabilitation criteria, and also for those boards and bureaus which can continue to consider a denial of an application beyond the 7-year washout period for certain financial crimes that are directly and adversely related to the business and profession for which an individual seeks licensure. So beginning first with the substantial relationship criteria, information on this can be found in your item on page 3 and the top of page 4, and the language itself in attachment 3 for the item. AB 2138 requires specific text be considered when evaluating substantial relationship, and those are noted in the 3 bullets. The language DCA developed sought to include these new criteria similarly to how staff had previously proposed. DCA noted that the various boards and bureaus had language that fell into basically 2 categories. First, those that simply have regulations requiring evidence of present or potential unfitness to perform the functions of a license. And second, those that had the same language but also included a list of crimes and acts the board or bureau determined to be substantially related. However, those lists were not considered to be exhaustive lists. The CBA's present substantial relationship criteria falls within the second category, and the language that's being proposed, that was originally proposed by staff and continues to be proposed by staff, falls within this second criteria. In the text members reviewed in January, the crimes and acts of professional misconduct were separated into 2 individual subdivisions. In reviewing the DCA model language, their language wasn't presented in that form, and actually it was more concise and created an easier read in the language. So taking into consideration that example, staff have reformatted the text to more closely align with the DCA model. As for rehabilitation criteria, this can be found on pages 4 and 5 of your materials, in addition to the actual text being in attachment 4. Again, AB 2138 necessitated some changes, as noted in the bullets on page 4. The original language presented by staff at the January 2019 meeting took a pretty direct approach and simply inserted the language into the rehabilitation criteria. The approach presented today continues to take that kind of direct method with some minor formatting changes to aid in the overall reading of the regulatory language. Staff did perform, again, a review of the DCA model language, and again, DCA's model kind of fell into two primary options. The first model is similar to the model presented by staff and continues to allow the boards and bureaus discretion in evaluating applicants' and licensees' rehabilitation efforts. The second model provided by DCA it appeared would significantly limit boards and bureaus' discretion on rehabilitation when evaluating individuals with criminal convictions. The second model would move from what is termed as a showing of rehabilitation to another term of finding of rehabilitation as it relates to individuals who completed the criminal sentence at issue without a violation of parole or probation. The second model that DCA presented appears to draw from a prior iteration of AB 2138 that would have made boards and bureaus consider completion of criminal sentence without a violation of probation or parole to be a finding of rehabilitation. When AB 2138 was originally considered by the CBA opposed this particular element of AB 2138. The bill was eventually amended to remove the requirement of making a finding, and in its present form, as adopted by the legislature, was a showing of rehabilitation. Given that the CBA opposed such a model in the initial amendments included in AB 2138, and again, now that AB 2138 is passed and does not call for such a model, staff have not prepared the draft language to reflect the variation of that model originally proposed by DCA. In addition to some minor formatting changes, staff are recommending the CBA add a new subdivision in its rehabilitation criteria, and it's subdivision B. This language would increase clarity to the fact that any criteria included in rehabilitation is considered a showing of rehabilitation. This further emphasizes CBA's ability to weigh matters on a case-by-case basis, taking into consideration the totality of the facts and circumstances for each matter. Lastly, as for the last area of regulations, staff have prepared draft language to add a new regulation, CBA Regulations Section 99.2, related to directly and adversely financial crime criteria. Information on directly and adversely financial crime criteria is found on page 5 and 6 of your materials, with the regulatory language found in attachment 5. Again, I'd like to emphasize this is a whole new regulatory section, was not presented to the board at its January meeting, and is a new section to be added to the board's regulations. So as members may recall, AB 2138 created a carve-out for a select few boards and bureaus to continue to consider denying applications for licensure beyond the 7-year washout period. If an individual was convicted of a financial crime currently classified as a felony that is directly and adversely related to the fiduciary qualifications, functions, or duties of the business or profession for which the application is made. The CBA requested, as part of its sunset review, a proposal to have the criteria amended from directly and adversely to substantial relationship criteria and remove the word fiduciary. As was discussed earlier during the legislative committee, staff working with the primary author of last year's bill, AB 2138, specifically Assemblymember Chu, there was an agreement was reached to remove the word fiduciary, but the directly and adversely test would remain. DCA did provide a model proposal for this section, which staff have reviewed and determined it offered a good model for CBA consideration. The DCA language, using the contractor's state licensing board, developed a list of crimes, though it's not an exhaustive list, that was reasonably comprehensive for inclusion into a proposed regulatory language. The approach used by DCA to develop the list was designed to provide a legally defensible position to support the list of crimes. The method used included compiling a list of all financial crimes for which CSLB had denied licensure over the previous 5-year period. As this approach provided a good base for developing a list of crimes, staff employed a similar approach with adjustments taking into considerations the differences between the CBA and CSLB, the most notable difference being the overall size of the licensee and application volume between CBA and CSLB. CSLB receives considerably more applications than the CBA and therefore sees more criminal convictions that lead to the denial of licensure. So to account for this discrepancy, staff used a methodology to evaluate all denials and license discipline with financial crimes over the previous 7-year period, so 2012 to 2018. This provided a more comprehensive list for which to create a regulatory language, and that list is included in subdivision B of 99.2, and the list itself is included in attachment 7 to your materials. As for the language for developing directly and adversely criteria, was drawn from language prepared by DCA and ties the direct and adverse impact to having a direct and financial benefit to the applicant or another person, or direct financial harm to another person or to an entity. As members consider the language included in your materials, I would like to note that to stay on the timeline developed by DCA for implementing regulations for the July 1, 2020 implementation of AB 2138, the rulemaking file needs to be to DCA by May 1st. Therefore, it requires the CBA to adopt language at this meeting. Staff have identified a fiscal and economic impact for these regulations, which is outlined on page 7. Staff anticipate there will be minor and absorbable fiscal impacts for CBA operations to implement the proposed regulatory text. Staff also anticipate that there is an economic impact, but it will be extremely negligible, as it will only affect those very few individuals disciplined by the CBA as compared to the totality of its licensee population, and who are and specifically those individuals who are disciplined and actually put on probation. So therefore, staff recommend that the CBA make a motion to approve the amended regulatory text to the disciplinary guidelines and model orders 10th edition, approve the amended regulatory text in CBA regulations section 98, 99, and 99.1, approve the proposed regulatory text and adopt CBA regulations 99.2, direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer, and Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. At this point, I'm happy to turn it back over to the chair, and I'm happy to answer any questions that I can.
Thank you, Mr. Franzella. Before we proceed any further, I have asked the CBA's legal counsel, Ms. Boutou, to give us some information, some parameters and guidelines in connection with information that we as members bring to the meeting that may enter this discussion. So, Ms. Boutou, would you do that, please?
It's my understanding that there will be some discussion by a board member who is who's going to be offering an opinion regarding the substantial relationship criteria that's going to be discussed today. And as a board member and any member of the public actually can submit their opinion regarding what they believe substantial relationship means and how it should be interpreted. So I encourage everyone to do that. But if anyone has any of the board members or committee members have any questions regarding the legal implications or any of the legal terminology being used, or would like my take on the perspective, by all means, I'm here to answer any questions that anyone has, and I guess we can go forward.
Okay, so do we have any questions or, I'm sorry, Mr. Franzella? Do we have, I'm sorry. Do you have any questions or, yes, Mr. Jacobson?
As Elena's hand gestured toward me when she was talking about a board member, I believe that it's me that she is, of whom she is speaking. At our last meeting of this committee, I asked staff for a list of citations where the word personal, the phrase personal judgment, is included in the definition of professional misconduct. In response, I received 3 cases, just for those of you who aren't lawyers, cases, that's law, just as if the legislature wrote it. So I reviewed those cases, and I've written a memorandum, which in accordance with the government code, I have available here for anyone who would like to see it, including the public, and if anyone in the public has any disability, I'd be making it difficult to read this, I'd be happy to help out. But I'm going to briefly discuss my arguments. It's one word.
Can I just make one point before you begin, Mr. Jacobson, and thank you for your very thoughtful memorandum on it. In our January meeting, you did raise the issue of communicating about this issue, which is a very important issue, and I think we all would agree on that. I question, and I ask counsel and all our fellow board members and the public, is this the most effective procedure and process that you're using? And I think that deserves some debate after you explain your position, which I have I'm not making any judgment on, because it's very well written and very well thought out.
I appreciate that, Mark. And with that in mind, I did not send this out earlier. I did send it to staff because I thought that was appropriate and courteous. So, one word, personal. 2 words, personal judgment. And what is the relationship, what does that have to do with professional misconduct? 2138 does not mention the phrase personal judgment at all. It's not mentioned anywhere. The cases that I was presented with are all of the board members were presented with those cases. All of those are healing arts cases. And the courts have been very, very specific that doctors, nurses, healing arts professions are treated differently than accountancy, than optometry. Maybe optometry is a healing arts profession, but they are treated differently than other professions. To cite what the courts have said, the courts have had the opportunity to describe the unique position of influence of those who are licensed to practice the healing arts. The courts have also distinguished the healing arts professions in not only having technical complexity, but in also having an intimate relationship to public interest and welfare. Healing arts professionals literally touch our outsides, our personal parts, our insides, and accountants have no such intimate relationship. Another court said, there is no other profession in which one passes so completely within the power and control of another as does the medical patient. Now, without doubt, the state has the right to require that the possessor of a license to practice medicine and surgery shall be a person of good moral character. That's what the case says. And that good moral character issue may deal with personal judgment. And there is no such comparable thing in the Accountancy Act. So generally speaking, these healing arts cases simply don't apply to non-healing arts professions. Specifically, the 3 cases, Mustafa versus Board of Registered Nurses, Personal judgment was not mentioned in Mustafa. It's not anywhere in the case. And the conduct on which the court based its decision, the court specifically said, until July 1, 2020, when Assembly Bill number 2138, the very one that we're working on, goes into effect, the Board of Registered Nursing may rely on the conduct underlying dismissed convictions. So it's the case by its own words isn't relevant, except for maybe the next 10 months. But I don't think we want to make a rule for the next 10 months. SOLA versus Board of Registered Nurses. Like Mustafa, SOLA never mentions the phrase personal judgment, except when it's quoting Griffith, which is the next case that comes up. SOLA is a statute-based case, a statute that is specific to the healing art of nursing. The case says that a certain code dealing with nursing provides that a licensed nurse engages in unprofessional conduct when he or she uses alcoholic beverages to the extent or in a manner dangerous or injurious to himself or herself or any other person or the public. That's what the statute says. The case goes on. Or is convicted of a criminal offense involving the consumption of alcohol. The Accounting Act has no comparative rule. And the last case is Griffith versus Superior Court. Like Mustafa and SOLA, Griffith is a healing arts case. And like SOLA, it is also based on a statute. The case says that a certain code section provides that if a physician sustains 2 or more misdemeanor convictions involving the consumption of alcohol, those convictions constitute unprofessional conduct. You know, in fact, Business and Professions Code Section 2239 also makes the record of the convictions of alcoholic consumption conclusive evidence of unprofessional conduct as to doctors. These are all healing professions. In general, they can't apply to our profession, which is not a healing profession, and specifically, they don't apply at all. So, I think a very objective thought is, well, the objective question is the proposed regulation, specifically I'm talking about Title 16, California Code of Regulations, Section 99B4, which states that professional conduct includes personal judgment relevant to the practice of public accountancy. Is that so vague that people of common intelligence must necessarily guess at its meaning? And the reason I ask that question, that objective question, is because the California court quoted the United States Supreme Court in saying a statute which either forbids or requires the doing of an act in terms so vague, or the not doing of an act, I think it says, in terms so vague that men of common intelligence must necessarily guess at its meaning and differ as to its application, and that act would violate due process of law. So you might have someone whose personal judgment, an accountant, whose personal judgment is that rich people should pay high taxes, and therefore, because of personal judgment, the accountant says, we're not taking this deduction. You might have another case where an accountant, because of personal, subjective values, as opposed to his or her professional values, says that he or she believes that the personal judgment might be that the accountant is very risk averse, doesn't want to get up in the morning because might get into trouble. And because of that personal judgment, makes a decision on his or her accounting. Says we shouldn't do this because of that. That's not a professional judgment, that's a personal judgment. And to sum up, AB 2138 does not mention personal judgment. None of the cases provided by staff has anything to do with 2138 as to accountancy. And in the context proposed, personal judgment is so vague that people of common intelligence must necessarily guess at its meaning. And because of that, I simply ask that everything else looks great to me. Section 99, B4 in Title 16, the words or personal judgment be excised so that it says relevant to professional misconduct, whether the crime or act of professional misconduct reflects a lack of sound professional judgment relevant to the practice of public accountancy. Thank you.
Thank you, Mr. Jacobson, and for all of that information. We appreciate that. Any other members have anything to offer?
I think there's a very thin line between professional and personal judgment when it comes to accountants. You're using an abstract. What about being a drug addict or an alcoholic? Is that a professional decision or a personal decision to do that while you're practicing your profession? So I think there's a very thin line. And to talk about healing arts being personal because you're touching somebody versus an accountant that makes a lot of personal judgments in what he's doing as a professional, takes this all into account. So I hear what you're saying, I just don't agree with it from this particular point of view. And having practiced for 45 years, while my personal judgment is always there, I must still act as a professional. And in terms of expenses or whatever, there are rules to follow. And accountants have prepare and negligent penalties in putting deductions on tax returns that are not proper. So, you know, there is always personal judgment or bias, but we as professionals must act accordingly. So,
Thank you. Anyone else?
If I may respond very, very briefly.
Certainly.
One, as to being an alcoholic or something like that, I can speak from very personal experience in that I am an alcoholic who hasn't had a drink in over 20 years. If, while I was drinking, I rendered a legal decision, as I'm a lawyer, I rendered a legal decision that was affected by that drinking, boy, I should be in trouble for my professional misconduct. And as for the other situations that Michael rightfully brought up about knowing, but always having his personal judgment, it's not his personal judgment for which he should get into trouble. It's when that personal judgment affects his professional conduct and makes it professional misconduct. And in that case, he's not in trouble for his personal judgment. He's in trouble for professional misconduct.
Okay. Anybody else? And I wanted to add, too, that as far as intimate relationships, it just strikes me that, and I realize it's not the inside, the outside of the body, we're not doctors, we're not dealing with, surgery, that sort of thing, but I can think over the years of so many clients that valued their financial information maybe above and beyond their health, where I'm just saying that is very common to see, but we can certainly do things as professionals that can destroy their ability to make a living, lose all their investments, and there's a domino effect to that, as we see in many of the cases that we review. So it's quite intimate. We're privy to everything about them, and many times their health concerns as well. So, anybody else have anything to add? Yes?
I just am uncomfortable with the differentiation between the practice of accountancy and the healing arts, the application of the regulations and the missions. We are part of the Department of Consumer Affairs. Our agency, and this practice is regulated under the Department of Consumer Affairs. And I think part of the rationale behind that is the protection of the public and the instillment of confidence in the public that the practice is being managed and overseen. That is valuable in our society. Confidence, transparency, faith that when you go to someone and entrust them with something that is important to you, that they're going to exercise not only good professional judgment, but they also are going to exercise good personal judgment in taking care of you as their client. And so I'm not as comfortable with the idea of making such a stark differentiation between the practice of accountancy and the healing and the non-healing arts, let's just say that. Because I think you can make an argument that many of the other professions that are regulated by the Department of Consumer Affairs have similar intimate relationships with their clients. I have a very intimate relationship with my hairstylist, and she's not touching me in the same way that my surgeon is, but it is a very personal relationship, and the idea that that she is regulated by an agency under the Department of Consumer Affairs, I think that there's an important purpose that's, served there. So I just, like I said, bring up that I'm not comfortable with making such a stark delineation between the healing and non-healing arts, and the weight of whether personal judgment is clear. I'm not sure that's something that is compelling. That's an argument that's compelling right now.
If I may, please.
Yes.
The distinction, the stricter standards, the higher standards for personal judgment as for healing professions is not my judgment. It's not our judgment. It's a judgment that has been made by the courts time and time again, and therefore it's the law. And we have to follow the law.
Well, but that's a legislative decision. I mean, in this case, the legislature has decided to add in the personal judgment. I mean, we're making the recommendation that the legislature pass this law, including that terminology, but we're making the recommendation to the legislature, but it ultimately is the legislature that makes the decision that is going to be the standard. And then the courts come along and determine whether or not the legislature made an appropriate determination as to what the standard should be, or whether it was, constitutional or consistent with precedents. So the CBA is making a recommendation to the legislature to amend the law, but it ultimately is the legislature that should decide whether or not this is an applicable standard.
This is not a this is not a recommendation. This is a regulation that we would be making.
That is subject to their acceptance for
They- yeah.
denial.
Not the legislature's
No.
acceptance. It's subject to the acceptance of the Office of Administrative Law.
Okay.
But please do not discount the fact that when the courts make a decision, it overrides anything that our regulations may say. And the courts have said that the stricter standards are applied to the healing arts.
Okay. Is there any further discussion from any of the members? Are we ready for a motion? Can I have a
Well,
motion? Well,
I move that the entirety of the staff's recommendations for the regulations be adopted, except for 16 of the, Title 16 of the California Code of Regulations, Section 99B4, where the words "or personal" be redacted.
and do I have a second to that motion?
Before the committee votes, I do have some things I'd like to add, but I'm not going to stop you from making your motion and discussing, but just before you vote, I'd like to say a few words.
Thank you. Before we vote, okay. Well, I have a first, I do not have a second. So do we just, at that point, call for the vote? I mean, we don't have a, we're at die.
Motion
Okay,
fails.
so another motion. I'm ready for another motion. May I have a motion, please?
I move to adopt, to recommend that the staff's recommendation for all changes and to move forward to rulemaking.
Okay, and do I have a second?
Second.
I have a second. Any further discussion amongst the members? Any other discussion then? Thank you.
Just a few things I'd like to add and to clarify any of the points, or maybe a couple of the points that Mr. Jacobson made. So these three cases that I provided, there are a multitude of cases on this topic regarding substantial relationship and how it relates to varying professions. It just so happens that the medical profession has the vast majority of these cases, so believe me, it's not by design that I'm trying to only provide you with healing arts cases. It's just that's what it is. But basically, substantial relationship has been honed by the courts over the years since like the 1950s. And I agree, yes, this is, case law, which is why they call it case law, because ultimately it becomes how you implement the law. But I also wanted to point out the reason that these three cases were brought to your attention. Mustafa happens to be a very recent case, and that is why it's on here. And yes, it's about the Board of Registered Nursing. It's about shoplifting. And the court noted that that the fact that she was shoplifting indicated that she had, that there was a potential unfitness to practice nursing in a manner that's consistent with the public safety or welfare. And I think that, granted, it's shoplifting and it's not inappropriate touching, it's a different kind of thing, but the court noted that nurses hold positions of extreme trust and have access to the property of others, which CPAs also do. So I just wanted to kind of point that out. With Sulla, this is an often cited case, and I included Sulla and Griffiths because they're tied and because DUIs often come up in disciplinary cases, and there's often discussion regarding whether a DUI is considered substantially related. Well, these two courts both said, first, Sulla said, actually, I'm sorry, Griffiths said, you're going to have multiple DUIs, you're a physician, you should know better, and this shows poor judgment. So it's substantially related and you should be disciplined. Sulla just takes it one step further and says, okay, you know what? Sometimes one DUI is going to be enough to show that you have bad judgment, and therefore we don't think that you're safe, and we don't think that you can practice in a manner consistent with public safety or welfare. And I only provided 3 cases because I didn't want to overwhelm you with a ton of information, and I know that Christy and Mr. Sane had given a presentation regarding substantial relationship a few years ago to the board, and I know that, well, I'm pretty sure that the board members, most of the board members are the same board members, maybe there's a few new ones. My understanding also is that either Dominic or maybe Carl provided this presentation to Mr. Jacobson a while ago with all of the same cases. And again, you are not attorneys, and I provide you with the best legal counsel that I can. And it was in my judgment to provide you with a one-page quick and dirty, not quick and dirty, but a quick, brief, something that's not too meaty, something that you can kind of wrap your heads around a little bit to kind of help you with the most often issues that come up, which is usually going to be DUIs or some kind of substance abuse. So I wanted to point those out. But I do want to also draw your attention to, there's a couple other cases that I think you should be aware of. One is a California Supreme Court case from 1990. It says about an attorney. This attorney also, DUI, because, there's a reason the attorneys tend to have this problem. We're all stressed. Anyway, so this attorney was disciplined for a second DUI, but the court decided that it was relatively minimal discipline was necessary. And this is because the court did find a nexus between the misconduct and the fitness to practice law. Court found 2 reasons for that. They were saying that the attorney, just as an attorney, should have known better to disobey a court order that placed him on probation from his first DUI. And therefore, that kind of calls into question his ability to follow the law with regard to his clients. And you want to protect your profession to show that, hey, we're good, honest people, we're your attorneys, we're trying to help you, and we want to also show you that we can follow the law ourselves. And the second one was that repeated criminal conduct and the circumstances that were surrounding it are indicators of alcohol abuse that affects a licensee's private life, which should not be ignored until the problem begins to affect the practice of law. That statement, that last part about it should not be waited until, you don't wait until it actually begins to impact the practice of law. Courts have said this time and time again, which is why discipline often happens, why, maybe not this board necessarily, but a lot of healing arts boards, they do put licensees on probation with testing, with drug and alcohol testing and monitoring when they have an alcohol or any sort of abuse problem, because they want to protect the consumer before it happens. There are many, many cases that say, we want to catch this before someone gets hurt. And there's also many, many cases, and almost all of our discipline cases should say that this kind of discipline isn't to punish, but rather to protect. So this is considered as a prophylactic measure. We're looking to protect the public, and if the board sees an issue that it believes could kind of spill over from your private life into your personal life, that is what the board is concerned with with reviewing, with having some sort of oversight over that individual.
Did you mean public life into private life?
No, if your private life,
Well, you
say-
said personal life to private life is, I was.
Oh, I'm sorry, I misspoke.
Oh.
Basically, if your private life can spill over into your work life.
Okay.
Professional is what I'm trying to say, and it didn't
Okay.
come out that way,
Okay, I just
sorry.
wanted to just make sure I was clarified.
No, you're right, thank you.
Yeah. Okay, well,
Yes, please.
So I have a question.
Yes.
So we all know our former board member, Larry Kaplan, who I'm having lunch with next week, which I'm very excited about. So this was his big thing on this board. I mean, he talked a lot about, if that in terms of drug and alcohol use, if it, it shouldn't have anything to do with the practice of accounting. So for example, and we debated, a lot of our former board members who are not with us, they're off the board now. At the time when I came on the board, it was a big deal. We threw the book at pretty much everybody. And some of Larry's arguments were actually, I took to heart. So for example, if an accountant is going to a wedding on the weekend and he gets a DUI or she gets a DUI, and they learn their lesson, it's going to be it's humiliating, that type of thing, but it doesn't affect what happens during the day. They made a mistake. How does that relate to what we're talking about now? I am a non-lawyer, I am a non-CPA on this particular committee, and so I need you guys to kind of like talk to me to where I can understand this. You can recite case law all day. I'm not a lawyer, I don't know. So, but how does
Well, I
how
agree
does
with
that
you.
hurt?
There is a fine line.
Right.
And where is the line? And that is
Well, and
really
we-
difficult to define, and
But everything that we do and that you do is on a case-by-case
Exactly, and
basis.
right,
Exactly right.
And
That is an extenuating circumstance, has
Right.
nothing to do with their job.
Right.
It's
And the
the
reg
repeated
allows
offenses
Exactly, and that's
of
why I want to make
alcohol
sure Dave
abuse.
understood.
And you
Yes.
can't tell me somebody always starts drinking at 5:30 or 6
Mm-hmm.
o'clock at night if they're an alcoholic.
And you're absolutely right. I have an accountant friend of mine who's a CPA, and he said the exact same thing. He goes, I like that we're being held accountable. He's like, I like the fact that we are being, governed by you to make sure that I do the right thing. So I'm with you on that. So I just want to make sure that we're not, and I like going by the case by case. Because
Oh,
one stupid mistake is not, we shouldn't be punishing someone for one stupid thing that happened.
absolutely. And the way that I read the staff's proposed regulation language is not to, in every case, say this is going to be substantially related and we're going to do something about it. Basically, it's the discretion. We are going to look at these factors, we're going to see, because basically the analysis is this. You determine whether something is substantially related or not, and then you decide if discipline is warranted. So just because you can find that something is substantially related and say, you know what, yes, but we think that either we're going to do minimal discipline like the In Ray Kelly case or no discipline at all, maybe, there's a wide variety. There's doing nothing to doing everything. So I am not a proponent of in every case, this is what it is.
Right.
But the whole point of all of this in the case law and all of this discussion is to just basically say that the board is trying to flesh out what you guys kind of think this is going to look like so that they have something to point to when they have a discussion. So the board members know what the parameters are and can kind of have a starting point for discussion and then decide, you know what, this is worth disciplining or it's not worth disciplining. But at least it kind of gives some people, or it gives licensees, I think, and maybe there are ways to rephrase the proposed language, and I actually have an alternative if you are interested in hearing it. And it was one of the options provided by DCA, and it was the Board of Pharmacies, by the way. And this is just to facilitate pointing people in the right direction so that they have a sense of, oh, so you think that maybe what I do in my personal life may impact my accounting profession, and if it does, I need to be aware that there may be a link. So while I may not agree necessarily with Mr. Jacobson's position regarding that it's so unclear that you can't understand it, I recommend and I encourage the board to look for language that would be more clear, that would kind of get to the same point but maybe differently. Anyway, so I just wanted to, I know I went on longer than I had intended, But I just wanted to kind of give you a sense of, there's other cases, there's a different position, there's other things. And basically, all DCA entities have the same consumer mandate, which is protection, and they all implement the case law in the same manner in terms of they use these cases as guidance, regardless of whether they're a healing arts board, because we also have engineers, we have geologists, we have barbering and cosmetology. I mean, contractors. When I think about the plumber coming into my house, do I want to know if something bad might happen to me because I'm alone in my house with my contractor? So things like that is just, we're all here for the same reason. We're all here for consumer protection, and we're just trying to flesh out what the guidelines are going to look like.
In the course of this discussion too, although I am a lawyer, I don't practice certainly with the, expertise of Mr. Jacobson, but I do bring, some understanding of the law and the relevance of precedents and the impact that it can have on our decision-making. So, just for context, since I have been on the board, I served with Mr. Kaplan as well, and since I have been on the board, there has been a shift in how this board makes its considerations and determinations of substantially related. And so while I appreciate Mr. Jacobson carrying on that concern, I don't think that the way in which the board applies that substantially related standard is it's applied in the same way that it was being applied during potentially Mr. Kaplan's tenure on the board. I mean, I would say that he could probably be credited with helping move the board along in being more deliberative and more thoughtful about how the substantially related standard is applied. So while I appreciate the importance of Mr. Jacobson, continuing to hold us to be mindful and conscientious of, whether we are operating in a way that is consistent with the law as it has been interpreted by courts. I think that by eliminating the language, we are being as absolute and extreme, potentially as Mr. Kaplan and others have been concerned that the board was, using the language inappropriately. So I would appreciate hearing the alternative language that our council would suggest, because I think that it gets to the concern that Mr. Jacobson is expressing, which is that we should be clear to licensees as to how we will apply these standards when, they become relevant. And we're not trying to, as a board, be just absolutist, and that we're open to making changes as they, as they're relevant or as they're appropriate. So.
We'd have to rework the language just a tiny bit just to make the sentence work. But basically, Board of Pharmacy says, it shall be considered substantially related to the qualifications, functions, or duties of a licensee or registrant if to a substantial degree it evidences present or potential unfitness of a licensee or registrant to perform the functions authorized by the license or registration in a manner consistent with the public health, safety, or welfare. So it says the same thing in a different way. I know. Dominic, I see your face.
So can I,
Yes,
the one thing I'd like to
please.
just point out is, maybe two things. One, the genesis of this particular regulation has nothing to do with 2138 at all, in the sense of the purpose of it behind 2138 was increased transparency in a way. And so this regulation that's being proposed and offered is consistent with the model the board already uses. Nothing is being changed with relation to the addition of this particular regulation. It's designed to provide increased transparency and clarification to the licensee population, who are oftentimes trying to debate whether or not they need to report a particular crime to us. They're required to report felony convictions. That's a blanket request. but only those crimes that are considered substantially related, and it provides additional transparency and guidance to those when they're dealing with a misdemeanor type crime, and they're weighing whether or not to report it to the board. So it provides that level of clarity. And again, the board's discretion is still is paramount in terms of the level, the degree, and whether or not discipline should be imposed is a second tier after the substantial relationship has been imposed. And to Ms. Burhout's point on Mr. Kaplan, the effect of the prior discussion is actually evidenced within the disciplinary guidelines themselves as being some of the proposed edits. Within the disciplinary guidelines, there's a caveat related to DUIs and personal drug use convictions and possession for personal use, that the board's taken the distinction into consideration and how it wants to dole out the discipline when considering crimes of those particular nature. So DUIs, drug use are within the disciplinary guidelines are already evidence that the board consider those substantially related because there's a specific carve-out for that particular issue as well. So I think this particular language is more just transparency. If it were to come out in its entirety, I don't believe anything would change from the board's handling of substantial relationship, at least in terms of how it weighs and evaluates the substantial relationship criteria. And if a matter, when we follow, Ms. Bowers and I follow the direction of the board, both in closed session and open session, of how they want to treat discipline, that would continue. And then when a matter comes before the board's actions during closed session and how they take discipline would continue to dictate the level of discipline. This is just establishing a criteria of substantial relationship that's consistent and adding increased transparency.
Okay, thank you, Mr. Frenzel. I just need to make sure there are no other comments or questions from the
One more
public.
thing, really quickly.
I think I was asked a question.
Okay.
I think Alicia, you said, could someone explain what the Sunday drive to the wedding has to do with accountancy? And I don't think it has anything to do with it. And thus, just taking out the word personal and saying that a sound professional judgment relevant to the practice of public accountancy, I think, is appropriate. However, I would like to ask Elena, I think you said, you used the pronoun it in the Board of Pharmacy's proposal.
Oh, I only read like half of it because, so I was paraphrasing. But basically, it says, a crime, professional misconduct, or act shall be considered substantially related.
If
I
understand.
Yes, if.
I think that's fine language.
So anyway, that was just my, alternative proposal for anyone who was interested. But I did want to add very quickly, because I don't want to forget, because I think it's a big deal. AB 2138 does change one thing. So basically, currently, so until AB 2138 goes into effect, currently, boards can deny a license based on underlying conduct as well as a conviction. But you can't, depending on how you plead the accusation, or how you plead and I know this is so lawyerly, sorry. In the statement of issues is the document that is used to deny a license. It depends on how it was drafted. So if you just draft it to include only the conviction, and you only have one conviction, that under current law, you can't deny a license based on that one conviction if it's been expunged. So if you don't plead the underlying conduct, which is, I'm sorry, I just have to explain this.
Yeah,
If you don't
you
plead,
kinda
basically, because, all right, so the conduct doesn't go away in terms of whether we can look at it, but the conduct has to have a conviction behind it when 2138 comes into being. Currently, you can say you were arrested for this. You weren't convicted, but you were arrested for it. You can say that's why we're denying you a license. You were arrested for, I don't know, whatever, some crime, I don't know. But you can also use a conviction. That's gonna go away with 2138. 2138 says you have to be convicted. So what a lot of attorney generals will do is plead, when I say plead, put it in the filing papers that you did this and you were convicted. So count one, count two. So it's kind of like double dipping in a way. But I know that's not maybe a very nice way to put it, but you're using the same concept of what happened in two ways. One is the bad act, and two is the fact that it resulted in a conviction. That's going to go away. We're only going to have just the second part, which is it's convicted. You have a conviction. Does that? I just wanted to point out that you can't, that AB 2138 is not going to allow the board, or it's not going to prevent the board from looking at what you did wrong. It's just in a different way, and it only matters to lawyers.
I'll vote for this thing just to get it to the full board and have a discussion on it. This is,
We have a motion.
We
Yeah,
have a
and a
motion,
second,
and we have a
yeah.
second,
Or-
and I'm just making sure that,
Yeah.
giving the public the opportunity, but it looks like we have nothing further. So can we call for the vote, please?
Mark Silverman,
Yes.
Michael Savoy.
Yes.
Dan Jacobson,
No.
Carrie Ann Farrell Hines.
Yes.
Nancy Corrigan,
Yes.
and Alicia Brown.
yes.
Okay, so motion carried. Thank you. Moving on to agenda item 3. Are there any public comments?
Can I
Yes.
just say one thing?
Please.
I don't want to belabor the process and procedure issue, and it's totally notwithstanding this substantive discussion. I just, and I don't know what level of communication with staff existed or not about this issue. I just prefer and would certainly like to hear from others that this item would have been brought up to staff. Staff would have then, with your document in hand, done some research on it, presented a discussion, evaluation, and then you would have had the chance to talk further about your position. And I think it's setting, whether it's precedent or not, I think it's setting a bad precedent for how we operate efficiently and effectively. And I would encourage the board and members to work with staff more ahead of time so that this could have been an even broader discussion.
Thank you. Agenda item 4, members, do we have any items for future agendas? Hearing none, the meeting is adjourned. Thank you.